Hey everyone, it's John with today's Active Self-Protection Extra lesson in our series that we're calling John's Briefs. And I'm here with Marc Victor, who is one of the premier self-defense lawyers in the nation. And there's a video that we had a little while ago that gave some interesting discussion on when are you not a defender anymore and instead when are you an aggressor. So I brought in one of the premier guys really in the world to talk about it. So let's talk about it. Today's video is made possible thanks to the generous sponsorship of companies like luckygunner.com. Please head to luckygunner.com and thank them for being a sponsor of Active Self-Protection. So Marc, first thing, how often do you see someone who is dealing with being charged with assault or aggravated assault as an attorney who comes in the door?
John, happens all the time. It's one of the more common charges in the criminal code. People don't understand the nature of assault, and we got to be a little bit careful here because assault is not the same thing from state to state. And so I'm a licensed attorney in Arizona. At common law, assault was divided up between sort of the classic assault, which is really scaring somebody, making somebody afraid of an imminent physical injury and having that intent. That was assault. And then there was battery at common law. Battery was the beating part. And so, at least in Arizona and many other states, both of those sections have been put together into the assault section. Right. So now we just call it criminal assault. Other states have criminal battery. So between those two things, probably you've covered all of the different aspects of assault. But in Arizona, there's actually 3 different ways you can commit assault. One is the intentionally or recklessly causing a physical injury. That's the classic definition of assault, right? That's what we see in this video. Some knucklehead comes up and punches another guy in the face, what appears to be an unprovoked way. That's clearly an assault. But you can also have an assault just simply touching another person if you have the appropriate, what we call mens rea. Mens rea is always what's going on in your head. Right. Remember, criminal law is broken down into 2 pieces. There's the mens rea part, what you're thinking, and then the actus reus part, which is what you're doing.
What you're doing.
You got to put those 2 things together before you get a criminal offense in most cases. We do have some strict liability crimes, but that's a different scenario.
So there's a bit here for us non-lawyers, right? So you have your mindset, mens rea, which is this idea of what was going on in my head. Did I have evil intent? And then actus reus, which was what I was doing, exhibiting an evil intent.
Yeah, and don't get too caught up in the evil intent part, because some people will sort of connect that with the malice concept in criminal law. And so there's a specific intent that's required. Like, for example, in Arizona, the first part of the assault statute that I was discussing about, your mens rea is either intentionally or recklessly causing a physical injury. So in the second part, which is just a touching, just something like that, if you touch another person, that's the actus reus part, with the accompanying mens rea, the intent to either injure or insult or provoke. Any one of those 3 mens rea statuses will get you an assault conviction in Arizona. Of course, the last one is the classic common law definition of assault that we just talked about, which doesn't require a touching in any way at all. A lot of people misunderstand this. This is a very common version of assault. People come in my office all the time. They're charged with assault, and they say, "Marc, easy case." And I say, "Why is that?" And they say, "Because I never touched the guy."
Yeah, but it doesn't matter if you put him in fear of being harmed. So I mean, like an honest example of this, if I go, "Hey man, it's good to see you," that's not an assault.
Not an assault.
It was a touch, right? But if I go, "What are you going to do about it, pal?"
Now you're provoking.
Now I'm provoking him. That could be charged as an assault. Now obviously, we're just playing games here, but that's simple. I don't even have to touch him. I can stick my finger in his face and go, "What are you going to do about it, dude? Huh? You got a problem?" Now that's an assault.
Sure. Another example might be, remember, it doesn't have to be touching directly onto your body. Say I knock your ball cap off. If I do that with an intent to provoke you or insult you in some way, that's an assault in Arizona. Again, just to be fair here, I'm licensed in Arizona, and I can speak generally about these types of things and also federal matters, but things are different state by state. Most of our criminal code is run in the state level, so you really have to check your own state's criminal code.
Of course, and you got to run that by an attorney who's licensed to practice in your state. And I would suggest not just any attorney who's licensed in your state, but somebody who is versed in and an expert in self-defense law, which is a very narrow section of the law of any state.
That's right.
So let's see where we got here as this one goes. We're going to superimpose this here and see what happens in this particular case.
These guys are just chilling in a bar when a guy with the beard here comes in with his buddy and a half behind him, and it's definitely a social fight here when he's going to step up to him and stick his
Now let's
chin
stop
out.
right there for just a second. So there was the assault. We saw the punch. But what do you think about before that? He's standing there. He's got his chin jutted out at the guy and yipping at him. At what point do you think that gets to a place where we could consider that assault?
Well, first of all, as you point out throughout your videos, really stupid to put yourself in this kind of a position. The smartest thing, of course, is always to avoid the conflict, live another day, and just move on if you can. As you like to say sometimes, eat your ego on this.
Let it go.
Excellent advice. But we can't hear what I'll call him the thug, the aggressor in this case, we can't hear what the thug is saying. I could imagine the thug saying something sort of the equivalent of, I'm getting ready to punch you in the face right now.
Right.
You could imagine that could amount to the variety of an assault where you don't have to touch. But we don't know what's being said here. And so they're probably just jaw-jacking at each other, and they're in each other's space. And so my take, at least at this point in the video, is you don't have an assault until that punch is thrown.
And now, an interesting bit. I hear people in the defensive community talk all the time about, well, that punch could be lethal. And so if some guy punches me, I can draw my gun and shoot him. What are your thoughts about that? So, I mean, we've just seen a punch. The guy just got punched. That was a pretty serious punch.
I get asked this question sometimes, and in the tort area, we have a term for this called an eggshell plaintiff. In other words, if somebody creates harm to another person and they're sort of in a position where they're like an eggshell, right? Maybe you just got surgery and there's something about your physical condition that a punch could kill you. You have a right to defend yourself in that circumstance. And that's actually a concern of a lot of people. I get people who are elderly, people who are ill. I had a guy one time who just got a surgery, and he said, Mark, a punch to the chest could kill me.
Yeah.
That's the situation. You have a right to defend yourself.
But let's say that it's not somebody who has one of those. I'm not frail. I'm not elderly. I'm not coming out of a surgery right now. You know, this video is two guys, you know what I mean, getting in it. Generally, without that totality of the circumstances, you're going to go, nope, that's an assault, not an aggravated assault.
Victim here pulls out a gun and shoots that guy before the punch. He's going to be prosecuted. No question about it.
So this is something to be aware of. Now, so that's, you know, what's going on in my world is different than what's going on in yours. Totality of circumstances, different than a 75-year-old grandma, you know?
Yeah, and you have to keep in mind you only get to use the least amount of force that's reasonably necessary to repel the attack. You know, I've had cases like this where people were absolutely justified in self-defense, but they went over the top. It's not carte blanche to start, you know, beating the heck out of somebody. So certainly pulling a firearm in the ordinary circumstance without the eggshell plaintiff type situation, pulling a gun on somebody who's just going to punch you in the face, that's going to be excessive force. And if you think about it, what you're actually doing is you're deploying deadly physical force in response to ordinary physical force, and you just can't do that. That's a prosecution on its way to you if you do that.
And again, this is this idea of you are required to use the minimum amount of force that is reasonably necessary to repel whatever that assault is. That's what you're required to do in the eyes of the law.
That self-defense is about defending yourself. It's not about inflicting harm on another person.
Let's keep going.
The answer he wants, he pops him once there in the mouth, and the guy still wants to talk. No, it's not talk time, it's fight time. And so our guy with the beard grabs a hold of him here, and he's going to slam him down and really go to work on him. And you can see his partner right behind him near the top.
Okay, let's go ahead and stop right here, because at this point, it seems to me as a defensive trainer, things have changed significantly.
No question.
Because now the guy who's been punched multiple times is now grounded, he's stuffed down into a corner, and a guy is standing over him. And now it's not only his fists, but it's also the ground and the stuff around him. This starts to feel to me like, gosh, a reasonable person might be in fear of grievous bodily harm here.
No question about it. I think even before you get there, the fellow who's the aggressor here, I think there's a very good argument he's committing an aggravated assault. And I think the reason that's the case, at least in Arizona, and that should be the disclaimer for everything that I'm saying, But a lot of these concepts are very similar state by state. But so I think what's happening here is the aggressor is now creating a substantial risk of a serious physical injury. Because if you go back to the video and you see that takedown, he slams him down pretty hard. His head just misses the table. Then there's a lot of punching to the face. As we know, that can cause substantial physical injury. It can cause substantial disfigurement, protracted disfigurement, those kinds of things. That is the stuff of aggravated assault. There are multiple punches to the face, and then we get to the choking. So I don't think that you would find a prosecutor who would think twice about charging an aggravated assault in this case.
And so that's a pretty significant shift, though. That first punch, maybe even the second one, now we're just talking assault. But once that guy's got a hold of you, you're on the ground, and he's leveraging you and really beating the tar out of you like that, now, regardless of whether you're eggshell or not, you probably say, no, at this point, if I have to, I can use deadly force to defend myself if I felt like I can't get out of here otherwise.
Yeah, and so I think that the aggressor has graduated from the lower misdemeanor court up into the felony court. And we should probably note that's a significant step up, because in a felony conviction, that's going to change your life. You're going to lose your gun rights, maybe forever on a felony offense. You're going to have a hard time getting a job. You're looking at prison. That's the definition of a felony. So becomes quite more substantial situation based on the aggravated assault. Now, to your point, the question arose in my head, if this victim here had a firearm, could he pull out the firearm and start shooting this guy? I think that's a close call, frankly, because if he did that and I was defending him, I certainly would make the case that he's at a very serious risk of a substantial physical injury. It doesn't have to be death. Certainly death is something you can use deadly physical force, but you don't have to suffer a substantial physical injury. And as I looked at that video, that looked like we were getting very close to that. Now, pulling out a gun and displaying it is different and would be seen different than pulling out a gun and discharging a round, right? So you have to always keep in mind it's the least amount of force that's reasonably necessary to repel the attack. But I suspect if that fellow pulled out a firearm and just presented it and that ended the situation, probably no charges there based on the brutality of the attack we're seeing at that point.
Things are going to get a little interesting here. Let's keep going.
Hanging out. This dude's buddies are kind of hanging out as well, just like, well, he's going to take himself an educational beatdown, and that's exactly what.
Now, something interesting that I missed in the original here, that one of his buddies is pulling out some weighted gloves.
Oh, I didn't notice that.
Yeah, I didn't either, and a couple of comments.
Is that the guy who's getting ready to sucker punch?
Yep, right here. He's got weighted gloves on. That's why he's got serious hands.
Well, let's talk about that.
So his buddy decides at that point he's going to put on some weighted gloves and weigh in to protect his friend. Especially because he punched a guy who wasn't actively in the fight.
I gotta say, John, this to me is not protecting a third party here. This guy, who may be friends with the thug, the aggressor as we've called him, he's just standing around. He's watching the show at this point, and the person who appears to be friends with the victim here just flat sucker punches him. And I think a prosecutor looking at that video is going to bring at least a misdemeanor assault charge on the friend for sucker punching the buddy of the aggressor here. And if you're right about the weighted gloves, that's going to be a dangerous aggravated assault right there. And he's going to be looking at prison just for putting those gloves on.
Right. So that, I mean, obviously, I said this in the original narration. I don't know that there are any good people in this video. I don't know if there's a whole lot of innocence going on.
I can tell you who I don't fault at all is the initial victim.
The initial guy who took the punches.
He gets beat up, and then as his buddy eventually comes over to kind of break it up, he just scrambles out of the way and he doesn't do another thing. He's absolutely clear of charges.
Let's keep a look here.
Stomp that guy too.
So there goes our dude that's getting out. Now, of course,
turns into a WWE cage match here with 2-on-1. These guys are going to look.
Guy using a chair here, he's going to catch aggravated assault charges too.
I think he's going to catch aggravated assault charges either for the weighted gloves, it could be for the shoes, or it could be for the fact that he is now committing an assault on somebody who is substantially unable to protect himself. This other guy who was sucker punched is basically on the floor and he's not able to protect himself. And at least in Arizona, when you commit an assault on somebody who's not able to sort of resist or protect, that's automatically going to be an aggravated assault. And so I think the buddy here bought himself an aggravated assault charge as well.
Well, and even the initial aggressor, okay, the guy who just walked up and punched some guy, and then he did terrible things and was just beating the tar out of him. Well, eventually, here pretty quick, he gets hit hard enough that he's out and they're still beating on him with the chair. Well, you can go pretty fast from being the victim to being an aggressor, from being somebody who was maybe justifiably defending themselves to going over the top.
Yeah, so let's talk about the guy with the chair.
Yeah.
This guy is apparently a friend of the victim, and he's not involved until this point. And he picks up a chair and he starts smashing the guy over the head. This to me is a close call. I think if I was the prosecutor, he would not be receiving charges on that. And the reason for that is the guy who's using the chair, you always have to look at the disparity of sizes, right? It's one of the first questions I ask in a self-defense case. What's your weight? What's the weight of the other person? The guy with the chair seems to be quite a bit smaller than the other fellow who seems to be the biggest, the initial aggressor, who seems to be the biggest guy in the entire melee here. And so I think it's reasonable for this other fellow to pick up the chair, even though he wasn't involved. It's a very important aspect of self-defense law. He gets to defend a third party who doesn't have to be his buddy. He could have just been someone outside on the street who witnessed this attack. He could run in and he can stand in the shoes of the victim and then do what the victim could have done, which is defending himself. I also note with the beating of the chair, pretty much the thug or the aggressor is not really stopped. He hasn't, the threat is not neutralized until it is. And as soon as it is, he puts the chair down and he flees.
Okay.
So I think that guy probably gets a free pass. It looks like a close call to me because there's quite a bit of beating with the chair on the head. But on the other hand, I think that you can still say the threat is ongoing. And so I think that guy probably gets a pass. But keep in mind, under the backdrop of all this, it's all about reasonableness. And you and I are sitting here and we are predicting what a randomly selected group of citizens from the local community would decide is reasonable. And that's always a tough call.
Yeah, so we can talk about what the law says and, you know, whether it's statutory law or common law or case law or whatever. But remember, anytime you put that in front of 12 random people who could not get out of jury duty, you are taking a risk.
That's true.
And you don't know what they're going to say. We've seen that in lots of cases that we read about or that I'm sure that you've adjudicated and taken all the way through.
Yeah, and to be fair about it, first of all, sometimes you don't get 12. You may get 8 on a smaller case. But second, there are people who either like being on jury duty or legitimately see it as part of their civic duty. I've never been on a jury. I'd love to be on a jury. For some reason, I don't make it to the jury. But I'd like to try to make the best decision I could do and try to get the right answer in a criminal case on the jury. But so I think it would be inaccurate to say, 12 people who couldn't get out of jury duty, that kind of thing. You may have intelligent people on the jury, and I think we should be fair and reasonable with them. But not all of them are well acquainted with the self-defense statutes. You could be a very bright engineer or doctor or something, and this may be all new to you. And you could also, some people are much more adverse to using force, right? There are people out there who don't like the ideas like we have in Arizona that you don't have to retreat. Because certainly some of these people probably could have retreated and just left, but you're not required to retreat in Arizona. So there are people on the jury sometimes who just simply disagree with the law, which is the reason why they take an oath to follow the law as it's given to them.
And that's, I think, an interesting bit that the jury does take an oath in order to do that. So I did make an assertion in the narration on that one that I said that many times a shod foot can be considered a deadly threat. You want to say anything about that?
Yeah. In fact, here's what my experience over the past 25 years has been. If it's just sort of a running shoe like you have on, normally that does not get charged as a dangerous instrument. And in Arizona, a dangerous instrument, deadly weapon get the same treatment. It becomes a dangerous felony offense, which is mandatory prison, even for someone who's a first-time offender. If they were a harder pair of shoes, like maybe the ones I have on, certainly a steel-tip boot, that is definitely going to be charged as a dangerous instrument. So you got to be very careful. Also, something like this pen. If you assault somebody with this pen, you're going to get charged with not just assault, but as a dangerous felony because of the dangerous instrument.
And now, I just want to kind of maybe wrap some of this up and recognize that I do have some people who say, well, yeah, but I mean, in the moment, you're not going to think about all that stuff. But understand, the jury is going to require you to be reasonable.
Yeah.
And you might say, well, but it's an unreasonable moment. That doesn't matter. If everything's crazy, you still, as a defender, have to act reasonably. So you have to be in control of your faculties. And you have to be able to articulate the reason, and that must be a reasonable reason why you did what you did.
Sure. The word reasonable always presents certain questions, because reasonable to whom is always the issue. And oftentimes we adopt an objective standard of reasonableness. We pretend that there's this sort of reasonable person out there in society. What would the reasonable guy have done?
Right.
Other times we look at what is subjectively reasonable for that person. In some states, like Arizona, have a section that deals with mistake of fact. In other words, you might be mistaken about the facts, but if the facts were as you thought they were, would you have been acting reasonably? Even if you were mistaken, Arizona will consider that type of an issue. That's not necessarily a majority position across the United States. This is one of the reasons you keep your mouth shut when you talk to the police after the incident.
What else you see here, man? Anything else that you see that's of real significance?
I think we've pretty much run it down. I think that the moral of this story is don't act like an idiot. This guy acted like an idiot, and there he is being pounded in the head with a chair. And to me, this was a just result here. I don't know what happened with the players involved, but that guy deserved a beatdown in my view.
Yeah, sometimes the educational beatdown is what it is, right? And then the lesson is always don't start none, won't be none.
You know how you avoid that kind of a problem? Keep your fists out of somebody's face.
Right. One of my favorite sayings of the Bangor, Maine Police Department, right? It's be kind to one another, leave other people's things alone, and keep your hands to yourself. And if you do those things, you'll probably be okay.
Said another way, use common sense.
Yeah, right. Well, Mark, thank you so much for the discussion on this, and I hope everybody recognizes that you're going to be required to be reasonable in any defensive encounter that you're in. So you better know these things ahead of time and get the kind of training and education that will help you make the right decision in the moment so that you don't lose the fight after the fight.